Hello again, this is Ben Hitchcock cross-talking to you today. Nobody's complained about the new lens so far, all zoomed up, so we'll see how it goes. Love that Sigma, love that color, love that blur. All right, this is a pretty good one here. We just have a short um, couple of pair of documents. God bless public records. We pay for them after all. All right, so let's see what we got. Bam. All right, we got Ramona Natera, the former bureau director, no, administrator of the it's the Equal Rights Division. So she's a division administrator. Ben, come on. Head the Hearings and Mediations Bureau is headed by a director. Got it. All right. Know your bureaucracy, everybody. That's something you can always take with you. Um, Wherever you go, put that in your pocket. All right. March 29th, 2023. Ramona Natera, they deleted or redacted some of that information from there. It might have had her address there before. And this is from, nobody else but Amy Petchacek. Look at everybody who's notified. Dear Miss Natera, I am pleased to confirm your appointment to the unclassified position of administrator for the Equal Rights Division, ESG3. I assume that is I don't know if that's a payroll or what that is. At the Department of Workforce Development, effective April 10, 2023. The position serves at the pleasure of the secretary. That means you can be hired or fired for any reason. In theory, no reason at all. Now, this is fascinating. Your salary will be approximately $119,225.60 per year, or $57.32 per hour. And the only thing I'm going to say about that is this person is two hops up from an administrative law judge, and I think an administrative law judge makes like 52, 53, maybe low 40s. Well, I guess we'll see in a second. But this is not significantly more than an administrative law judge. But that's, the nature of state government employment. In accordance with Wisconsin Stats 230-33, you will be placed on a leave of absence from your current attorney position for the duration of your appointment and for an additional 3 months after the appointment ends. During this leave of absence, you will have restoration rights to your attorney position or equivalent without loss of seniority. This is going to be very important to what's coming up, I think. You will also have reinstatement privileges for 5 years following your appointment to the administrator for the Equal Rights Division, or for 1 year after termination of the unclassified appointment, whichever is longer. Restoration rights and reinstatement privileges shall be forfeited if the reason for termination or of the unclassified appointment would also be a reason for discharge from the former position in the classified service. Well, that's interesting. You want me to translate that for you? Thank you for asking. All right, should we go to 230? Let's just do it. Well, what I like about this rule in particular is that it's the law. It's the statute of the state of Wisconsin. So, leave of absence and pay while serving in an unclassified position. Meaning, I'm going to assume a lot of people have thought really hard about this. Employees who have completed an original appointment probationary period in the classified service and are appointed to a position in the unclassified service shall be subject to the following provisions relative to leave of absence, restoration rights, reinstatement privileges, and pay. Okay, so this is really important. If you are a state employee and you've worked there for less than a year, you're basically a nobody and you can be fired for any reason or no reason at all, and they'll actively fire you if they think they need to. Um, so leave that aside. So then you're out of probationary status. But then what happens if you are then appointed to some position and then demoted down below? That's really what the big issue is. Appoint your regular peep, You get appointed to an administrator position, and then you're down to being a regular peep. What happens? Okay. A person appointed to unclassified position by the governor, elected, yada, yada, here, shall be granted a leave of absence without pay for the duration of the appointment and for 3 months there. Oh, okay. That's why it's a leave of absence, because they're really still at this position. All their rights from the previous position still accrue with seniority, because it's just not bad. That's hierarchy. That makes sense in the hierarchy or the bureaucracy, without a pay for the duration of the appointment and for 3 months thereafter. Okay, during which time the person has restoration rights to the former position or equivalent position in the department in which last employed in a classified position without loss of seniority. Okay, this is interesting. The person shall also have reinstatement privileges for 5 years following appointment to the unclassified service, or for 1 year after termination of the unclassified appointment, whichever is long. We read all that before. Okay, but here I think is the real kicker. Restoration rights and reinstatement privileges shall be forfeited if the reason for termination of the unclassified appointment, okay, and termination of an unclassified appointment is bureaucrat slash Wisconsin law speak for somebody who is someone who is working at the pleasure of the governor, who the governor is no longer pleased with, right? So we would normally call that terminated. But because these people are, yeah, what I'm trying to identify here is what I think is, we talk about hierarchy and classes within um, the workplace. These people, although they were working at will and so forth, they are in a different class than the peeps. Okay, so that's also what this is talking about. But this is interesting. Reinstatement rights and reinstatement privileges shall be forfeited if the reason for termination which we read before, of the unclassified appointment would also be reason for discharge from the former position in the classified service. So here's what I want to be very clear about that. Whatever this means, it only means something to the person who is the governor, elected officer, judicial body, or legislative body or committee. Okay, that person, they are the ones who ultimately are deciding here. I mean, you could go to a court and try to enforce this and say that you are entitled to these restoration rights because it didn't meet up. But here's why, and I can explain it very clearly. All because the governor, for example, can come up with any reason at all, any reason, then it will, if the governor wants it to bar you from further your old position, then it will. Because there's no like lock in place thing, unless the governor comes up and says, I just don't like you, then that obviously would not be a reason for you not to be an attorney. In fact, you're protected by the civil service. So all the governor would have to do in that fact opportunity there would say, I have concerns about your ethics. Boom. You're done. And fairly much irreconcilably so. I don't think I would see your chances of at being beating that in court to be slim. All right. I think we can back. But so that's very fascinating. So one thing we can say about this is if somebody is restored to has restoration rights and is taking their position, they could be terminated from their position with permission from that person who terminated them to retake their old spot. Is it clear to you what happens if the restoration? Okay, Now I understand it. You will also have reinstatement privileges for 5 years. So I take that to mean if you resign your position within 5 years, then you've got these restoration rights. Okay. So somebody is going back down to their old position less than 5 years. It still could be one of two things. They resigned to that position or they were terminated from to that position, but it still would be difficult to know how. We need to know more than just this next document that we have. Welcome to the department senior leadership team. I look forward to working with you on the opportunities and challenges that lie ahead and expect that you will communicate to administrative law judges during active hearings. Oh, I just added that. Sorry. God, I'm a terrible actor. All right. Now, so this is fascinating here. This is so, and I'm getting this for a reason because I asked for this a couple months ago. It's when we first heard about this. Now, is this in relation to the Stolar case? Is this relation to the hot mic? There's a lot of dates here that kind of line up with it. I'll gotta say that. Got to say that. This is, she's ultimately she's discussed fairly a lot. She's discussed fairly. Oh my God, man. Let's go back to commentation school. She is thoroughly discussed in the disgusting hot mic recording. Dear Miss Natera, this is December 11th, 2024. Whoa. That is a different date than I thought. I'm going to be right back with you. I'm checking this out. Yeah, local attorney not good with dates. Okay. I'm a little passionate now, but thank you. I just want to say I think there's very little doubt in my mind that this departure is connected to the hot mic recording and the contract for the Folaron case. Um, Based on the timing of public records productions that I received involving these people, these administrators for the Department of Workforce Development. And Tony Evers really has some explaining to do. The election has happened now, people. We can maybe afford now to have hold of people who are actually, if what I'm saying is believing to be the case is true. If Ramona Natera was removed because of the hot mic recording, why is Benitez Morgan still there? Why is Celsor still there? I mean, maybe Celsor is just following orders. I don't know. That would be a big question there. Hmm. Why isn't the people in the secretary's office? Why isn't Pamela McGilvery um, still there? Those are big questions that I would have because the documents, anyways, that I've seen say that Ramona Natera played the least role in all of this and has frankly been the better of everybody to talk with. Um, the best person and the most responsive. Um, Yeah, I mean, in general, there's clearly some internal communications in there, but again, what I've seen, and I've seen quite a lot, is the vast, the least, the least, the least. And I guess I take all of everything I just said back. I don't really matter to me where people are in the hierarchy of culpability and all this, but I would say if she is in any way culpable, then everybody, then Secretary Petchacek, then McGilvery, Then others in the secretary's office, um, certainly Benitez Morgan. Um, let's put it another way. Nobody but Benitez Morgan told Benitez Morgan to say what Benitez Morgan said. So that is, I'm just saying, if it's true again that Ramona Natera was pushed out or otherwise punished, this is a punishment in some way, or she was, I mean, the other alternative is she was simply disgusted with the DWD and went to there. There's probably other things, possibilities, but those are the two that spring to my mind right now. Because let's look at this little fact, Roni. In accordance with the state of Wisconsin's compensation plan, your rate of pay will be set at $50.64 per hour. The work you will be performing is exempt from the overtime provisions of the affairs. Oh my gosh. Okay. That thanks you for your continued service to the state of Wisconsin. So we know, did she even get her high three in? No. No, that's not even 3 years in that position. The high three, whatever your highest three paid years, even if you go down to being the dog catcher for your last 20 years of employment, if you were an administrator for 3 years, you're going to get an administrator's retirement benefits for the rest of your life. Um, I would this if this was involuntary, we would say this is an adverse employment action. I'm going to multiply 50.64 by exactly how many hours there are in a year, but I'm not going to let you know that I don't know exactly how many hours there are in a year. And I'm sure many of you adults out there were easily able to tell us that that was like $104,000. But so that's, you see what I'm saying? That's not like even a senior AOJ or whatever. That's not a big diff from the 119. Um, it's not 105. It's just not. So, hey, again, this would be an adverse employment action if it wasn't voluntary. We don't have any information one way or the other, but if it was voluntary, I mean, we can speculate on the reasons why it would be so. Um, and if she did the right thing, for example, more power to Ramona Natera. Again, I don't have any specific information. I've had less dealings with her than many other people. I don't have any specific information that I know of that she was, and I may be completely wrong on this, but nothing springs to mind right now that she was involved in. And I've had several conversations with her. I don't think I've ever had a conversation with Maria Salsor. Certainly, the secretary's office is so terrified of my presence that they moved the hearing and had, I mean, I went to St. John's College, for God's sakes. For God's sake. I could do this. Thanks for sticking with us. We'll keep you informed.